In Hong Kong, justice is a cornerstone of society. But what happens after a judgment is passed? How is it enforced? Let's take a closer look. There are several options available, depending on the precise circumstances of each case and the known assets against which the judgment can be enforced. A common way of getting a judgment debtor to pay the judgment debt is by issuing or threatening to issue bankruptcy or winding up proceedings. Strictly, however, these are not actually methods of enforcement, but they're similar to execution in that the purpose is to enforce payment of all proved debts of the judgment debtor. However, an unsecured judgment debtor may be a long way down in the queue when it comes to payment in a bankruptcy or winding up, hence may prefer to look at other methods if available. Where there are known assets against which the judgment can be enforced, the main methods include Garnishee Proceedings, which would typically involve enforcing against the judgment creditor's bank accounts, and charging orders against land or securities. If the judgment creditor knows of bank accounts belonging to the judgment debtor, one of the most common methods of enforcement involves what are called Garnishee Proceedings. This essentially involves getting a court order which compels the bank to pay whatever sum is in the debtor's bank account to the judgment creditor up to the amount of the judgment debt and any interest which has accrued, plus a fairly small amount of costs incurred in getting the garnishee order. Garnishee orders are not limited to bank accounts and can be obtained against any debt owed by a third party to the judgment debtor, although in practice, garnishee orders are most often obtained against bank accounts. It's fairly straightforward to get. The most important requirement is that the judgment creditor should have details of the judgment debtor's bank accounts. The application is made in two stages. The first stage is made on paper without notifying either the judgment debtor or the bank to avoid tipping off the judgment debtor and giving them an opportunity to clean out their account. The court will make what is called an order to show cause. This is then served on the bank, which will then temporarily freeze the account. The order is then served on the judgment debtor at least 7 days later to avoid tipping off the judgment debtor before the bank has had a chance to freeze the funds. A hearing will then take place with notice to both the judgment debtor and the bank to make the order to show cause final. Typically, it takes around 3 to 6 weeks for the first stage, that is, to get the preliminary order to show cause, and then around 6 weeks for the second stage, that is, from the date of the preliminary order to show cause to getting the order made final. Not very easy. Often, the judgment debtor will not attend. Even if they do, there is very little that they can say. They're not permitted to re-litigate the case. The court is simply concerned with being satisfied that the account belongs to the judgment debtor and that there is no reason why the funds cannot be garnished by the judgment creditor. Typically, the bank takes a neutral position and usually will not attend the hearing, but will write a letter to the court simply saying that they take a neutral stance and agreeing to comply with whatever order the court makes. Yes, you can garnish multiple accounts of the judgment debtor. Where a judgment creditor knows that the judgment debtor has various assets, such as land or securities, he can apply for what is called a charging order over those assets. While charging orders are most often seen in relation to land or securities, they can include, for example, an interest held by the debtor in any trust. The procedure is similar to applications for garnishee orders. The judgment creditor applies ex parte, that is without notice to the judgment debtor, for a preliminary order called the order to show cause. A sealed copy of this is then registered immediately with the land registry if the charging order is land, to put any third party on notice of it. If the order to show cause relates to securities, copies of the order must also be served on the company to whose stock the order relates. Copies of the order to show cause and the affidavit in support must also be served on the judgment debtor. There is then a second hearing to determine if the preliminary order should be made final or absolute. Once made, a sealed copy of the final order should again be registered immediately with the land registry if the property concerned is land. Where there is a risk that the judgment debtor will try to dispose of his property before the order to show cause gets made absolute, when applying for the order to show cause, he can also apply for an injunction to prevent such disposal. Of course, he must provide cogent evidence to support his contention that there is a real risk of the judgment debtor dissipating his assets. The charging order, when made final, does not transfer any legal or beneficial ownership in the property to the judgment creditor. However, after obtaining the final order, if the judgment debtor still fails to pay the judgment debt, the judgment creditor can apply for an order for the sale of the property, assets, or securities so that the judgment debt can be paid using the sale proceeds. This requires separate proceedings, which makes charging orders more expensive and procedurally more cumbersome than, say, Garnishee Proceedings. There can also be issues with regard to the sale of shares. For example, there may be a limited market for the shares in a private company. Also, in many cases, the articles of a private company may give the directors a power to refuse registration of share transfers, which may discourage potential purchasers or negatively affect the sale price. Stay tuned for our next episode. We will talk about oral examinations in the context of enforcement of judgments.